I will request all of you to put your mobile on silent mode. Let me start this evening with a very interesting couplet on lawyers. खुदा महफूज रखे आपको तीनों बलाओं से, खुदा महफूज रखे आपको तीनों बलाओं से, वकीलों से, हकीमों से, हसीनों की निगाहों से. I welcome all of you on behalf of our President, Justice Madan Lokur, our Vice President, Mr. Raju Ramachandran, and our Secretary, Mrs. Manik Karanjawala, and also the members of Tarkunde Memorial Foundation for the 13th VM Tarkunde Memorial Lecture, which is being delivered today by Honorable Mr. Justice Rohinton Fali Nariman. The topic chosen by His Lordship is Rights, Duties, Directive Principles, What is Fundamental. The last and the 12th VM Tarkunde Memorial Lecture was delivered by Professor Romila Thapar. She is with us today on December 6, 2019, and we are holding this lecture almost after 2 years because of the pandemic. During this interregnum, we lost our President, Mr. Soli J. Sorabji, and our Vice President, Mr. Ashok Desai. For both of them, I have this couplet to share from Jigar Muradabadi. सबको हम भूल गए जोशे जुनू में, लेकिन एक तेरी याद थी ऐसी जो भुलाई न गई. After the death of our President, Mr. Soli Sorabji, we have elected Justice Madan Lokur as our President, and we have elected Mr. Raju Ramachandran, Senior Advocate, to be our Vice President. Our President has the distinction of being a Supreme Court judge both in the northern hemisphere, that is India, and in the southern hemisphere, that is Fiji. I have now got a very pleasant duty to perform. I request Tahira Karanjawala, granddaughter of late Mr. Tarkunde, to present a bouquet of flowers to our Chief Guest, Honorable Mr. Justice Rohinton Nariman. I now request Mr. Raju Ramachandran, our Vice President, to speak about Mr. Tarkunde and also to briefly introduce our speaker. He will also, after his speech, invite Honorable Mr. Justice Rohinton Fali Nariman to deliver his lecture. Mr. Raju Ramachandran.
Good evening. Welcome. Vittal Mahadev Tarkunde was born on the 3rd of July 1909 and passed away on 22nd March 2004 at the ripe old age of 95. In that rich and full life, he studied agriculture. He was a topper in the matriculation examination. He could have chosen any glamorous course he wanted, but he believed that India lived in its villages, and so he chose to study agriculture. And then he went to England, became a barrister, also studied at the London School of Economics, returned to India in 1933 to practice law at Pune. The same year, he joined the Congress Socialist Party and the Indian National Congress, but left the Congress Socialist Party disillusioned with their vote against Subhash Chandra Bose. He then joined the League of Radical Congressmen, led by his mentor M.N. Roy. In 1940, Tarkunde, along with M.N. Roy, resigned from the Indian National Congress. He became a full-time member of the Radical Democratic Party in 1942 when he suspended his practice. He served as the General Secretary of the party till 1948, where the party itself was dissolved by M.N. Roy. The party's ideology was radical humanism. To propagate this ideology with M.N. Roy, he edited the Radical Humanist Journal and supported it with his own income. when the humanists of the world came together to sign the second Humanist Manifesto, Sri Tarkunde also participated in the deliberations and was a signatory to the manifesto. He resumed his legal practice in 1948, now at the Bombay High Court, and became a judge within 9 years in 1957. He voluntarily retired as a judge at the age of 60, though he could have continued till 62. The best phase of his life came after that. He moved to Delhi and set up his practice in the Supreme Court. Soon after that, the emergency came. Tarkunde played a pivotal role in the founding of the People's Union of Civil Liberties and served as its founding president. He was also instrumental in the Citizens' Justice Committee, which conducted investigations and fact-finding missions into the excesses of the state during this period. Tarkunde was a fearless lawyer, lending his services to the weak and the downtrodden, and was a much sought-after advocate during his years of practice in the Supreme Court. The first memorial lecture was delivered in 2006 by the late Soli Sorabji. Other distinguished speakers in this series of annual lectures have been Justice B.N. Sri Krishna, Dr. Kamal Hussain, former Minister of External Affairs of Bangladesh, Dr. Ram Guha, Justice Ruma Pal, Mr. Nandan Nilekani, Justice Santosh Hegde, Mr. Hamid Ansari, Justice A.P. Shah, who's with us this evening again, like just Ms. Romila Thapar, Mr. Gopal Gandhi, Dr. Pratap Bhanu Mehta. The speaker this evening, Justice Rohinton Nariman, doesn't require a detailed introduction because he is a contemporary hero. He is a connoisseur of classical music, an ordained Parsi priest, a student of comparative religion, a student of world history, a foodie, a hill person, a walker in the wild, a polymath, and an outstanding lawyer, and a great judge. And like Tarkunde, his best is yet to be after his retirement. Next year, in August 23, a day after his birthday, Justice Nariman will be speaking at the same forum, that is the Parliament of the World's Religions, and the same city, that is Chicago, as a representative of the Zoroastrian faith. The theme of next year's Parliament of Religions is a subject which would have made the late Tarkunde very happy. The theme is free speech in world religions. May I now invite Justice Rohinton Nariman to deliver the lecture.
Thank you, Raju. Thank you, Madan. My dear brethren, dignitaries, ladies and gentlemen, when this country was declared independent in 1947, it had a mammoth task before it. And that task was no less than drawing up a constitution which would serve its people and replace the English Government of India Act of 1935. That task was performed in a whirlwind 3 years, little less than 3 years as a matter of fact. And the preamble to this new document made it clear that there was going to be a completely fresh start. In ringing words, it begins with "we the people." So therefore, first and foremost, British rule was replaced by people rule. The preamble stated that we were sovereign. We were now our own sovereign, having thrown off the British yoke. And we believed now in the democratic way, which is that we will govern ourselves. Nobody will govern us. And we will have the republican form of government. Therefore, we are a sovereign democratic republic. The republican form of government being, as opposed to an antithetical to the monarchical form, that we will elect our representatives who will now rule us. Two other words crept in 1976, which were rejected in 1947 and then 1950. As a matter of fact, K.T. Shah and one other did their best to try and include the words socialist and secular. Dr. Ambedkar, who really was the piloter of the Constitution in that sense, felt that these words were unnecessary because they were already there, they were already reflected. The directive principles of state policy made it clear that we were going the socialist way. And there were so many provisions which made it clear that we were secular. But anyway, those two words have now been added. The roadmap was then set before us. The roadmap was that there will now be for we the people justice, which is social, economic, and political. By the way, political justice was achieved immediately by the stroke of the pen. Article 326 declared that in place of the very few voters that there was in the provinces in the British days, there would now be universal adult franchise. At that point, it was 21 years. It's now become 18 years. So political justice was achieved immediately. Social and economic justice had a very long way to go, for which we borrowed heavily from the Irish Constitution, which incidentally was a Roman Catholic constitution, which opens with the words that we are devotees of the Trinity and then of our Lord Jesus Christ. Now, very interestingly, after justice comes the three words which are the cri de coeur of the French Revolution: liberty, equality, fraternity. Liberty was to be of thought, expression, faith, belief, worship. Equality was to be of both status and opportunity. These one were to find largely in our part 3 or the fundamental rights chapter. And above all, fraternity was put almost in the forefront by saying that it was basic both to the dignity of the individual and, what is most important, basic to the unity, and then later the words "and integrity" of the nation was added. So the preamble itself shows us that there is a huge break from the past. For the first time, we have recognized fundamental rights and we have directive principles of state policy. First, fundamental rights. Fundamental rights can trace themselves back in Anglo-Saxon jurisprudence to Magna Carta itself, which is a document of 1215, which was wrested by the barons from King John, one of the wickedest kings that England was ever ruled by. And what survives even till today are clauses 39 and 40 by a statute of Westminster of 1297. And we are primarily concerned with clause 39, which said that no man shall be tried except by his peers and under the law of the land. The rule of law, therefore, as we know it, can trace itself to clause 39 as Magna Carta. In short, that there will now be no executive fiat, no arbitrariness of the king, but the law of the land will govern all of us. It took a number of centuries, ultimately, for Parliament now to grow as an institution and become a rival to the king in England. And so in 1689, when England had its glorious revolution, glorious why? Because not even one shot was fired to expel James II. His son-in-law and his daughter came and ruled as William III and Mary II. And thanks to their now rule, Parliament came out with a Bill of Rights of that year, 1689. Now that Bill of Rights was primarily Parliament against the king. You remember, Magna Carta was barons against the king. So parliamentarians were now given the right to free speech. And above all, excessive bails and fines were outlawed. Cruel and unusual punishment was also outlawed. Move on another 100 years, exactly 100 years. And you have two documents of seminal importance. First, the US Constitution, 1789. Second, the Declaration of the Rights of Man, which was born from the French Revolution. Now, most of our fundamental rights, as we know them, have some place in this Bill of Rights, which of course was added only by amendment, by the First Amendment, wasn't part of their original constitution. And these rights were pretty much the rights that we recognize today, and they are rights now no longer of Parliament against king, but of citizen now against Parliament in that sense, parliamentary law and the executive. So you see the mammoth leaps that we have taken through the centuries. You started with noble against king, then you went on to Parliament against king, and now you have gone on to citizen against Parliament itself. The Declaration of the Rights of Man was equally important in that it stated that these rights were natural rights which inhere in us because we are human. Something very important and something picked up by our court very late as 2017, to finally declare that yes, these are natural rights and they are rights which inhere in us. They are not something that is granted. So, after 1789, we come now to the UN Declaration, which was a result of the most horrible world war that took place between 53 nations. And post that world war, thanks to Mrs. Eleanor Roosevelt largely, we had a declaration now of fundamental freedoms as we know them. Very interestingly, the very first fundamental freedom is fraternity, because they realized, as Beethoven realized in the last movement of his Ninth Symphony, which he then set to music on Schiller's Ode to Joy, that until men become brothers, there can never be world peace. So the single most important thing which world peace requires is fraternity. And therefore you find it as the very first right, human right declared in the UN Declaration. Apart from this, you have other rights such as the right to privacy. You also have a right to leisure. And most importantly, you have the fundamental right to see that these rights are actually not only declared in name, but come down to the people and are justiciable by courts which are independent. So all these concepts you had, or rather the Constituent Assembly had before it. And therefore, it framed what is now called Part 3 of our Constitution. Part 3 begins with Article 12 to remind us that fundamental rights in essence are citizen against state. And state is defined very widely. because state will include legislative activity, it will include executive activity, it will include local authority activity and all other authorities under the government. So, the moment there is one citizen who petitions a court, a superior court, and says his fundamental right has been infringed, the state becomes the respondent and the state has to answer, and the state has no answer. The citizen trumps the state. This is extremely important. So, you then have the wherewithal of trumping the state in the next article, which is Article 13. Now, 13 is of seminal importance because again it says that the moment there is any law or executive action that is made which is contrary to a fundamental right, it will be declared by a court to be void, to the extent, of course, that it contravenes the fundamental right. And that declaration of voidness, therefore, will now inure to the citizen's benefit and will give the citizen relief. Together with 13, we have Article 32, which is a unique article, not found in any other constitution in the world, which specifically states that it is a fundamental right to approach the Supreme Court in order to enforce other fundamental rights. And it is through this mechanism of 32 and 13 that really all the great rights that are mentioned are enforced in favor of the citizen as against the almighty state. You have the great equality articles. We have Article 14, which is equality before the law and the equal protection of the law. You have Article 15, which again states that the state cannot discriminate on grounds only of religion, race, sex, place of birth, or any of them. You have Article 16, which guarantees employment in government to persons who are citizens. You have 17, which is a ringing declaration against untouchability. Parliament is then told that it must have an Untouchability Offences Act to see that this article is faithfully carried out. 18 is the article which deals with titles and says titles, etc., given by a foreign state are not recognized. 19 is very important. Now, please keep in mind both 14 and 19 because they will continuously crop up in this lecture. 14 and 19 are the two basic rights which inhere in us because we are human. One is not to be discriminated against, which is 14. 19 has a number of facets, each one of which is extremely important. The very first, which is 19(1)(a), is freedom of speech, and the court has read into freedom of speech and expression, freedom of press, most important. The curbs that can be put on this freedom again are only 8 defined subject matters, not general public interest. And the balance between free speech and these topics is what ultimately the court has to decide on by way of whether the restriction is now reasonable or unreasonable. The second is the great fundamental right of free assembly, again crucial to a democracy. The third is the right to freely associate and form unions. The fourth is to move anywhere freely throughout the territory of India, a right not reflected in the US Constitution. The fifth is a right to reside anywhere in India, again not reflected in the US Constitution. The sixth, which is a right which has since been done away with, was the right to property, which caused a lot of trouble in the 1970s and finally was done away with in 1978. I don't know whether it was correct or not, but anyway, it was done away with. And the last, again, is a right you won't find in the older constitutions, which is the right to practice any occupation or carry on any business. So these 7 extremely basic rights are all contained in Article 19. So when we speak of 14 and 19, please remember, you are speaking of a number of rights. You are speaking of the equality rights and each one of these rights. Under 20 and 21, we have the famous no double jeopardy. A person can be convicted only of an offense on the day that he has actually carried out the offense. There can be no ex post facto offense created. And the great right not to incriminate oneself. Article 21, which lay dormant for a period of 28 years, has now sprung into being. And it now guarantees not just life and personal liberty, but so many other things, which, for example, are the right to live with human dignity, even the right to privacy, which a 9-judge bench has now found, which Article 21 itself contains. And so on. We find in 23 and 24 the great declaration against any form of begar, any form of slavery, any form of child exploitation. 25, very important again, 25 and 26, religious freedom, subject only to public order, morality and health. And then we find the separation of church and state, or religion and state as it is in this country, because no tax can be collected from anybody for any particular religious purpose. And equally, what is important is that ultimately, when you teach children in a wholly controlled state educational institution, again you cannot teach religion. And if religion is taught in aided institutions, it is the option of anybody to opt out of that religious instruction. 29 is extremely important because it reflects the fact that we are an extremely diverse people. All cultural rights which a very diverse people have are preserved and protected. Now the word culture is very, very vast and subsumes a very large number of things that we do in our daily lives. And of course, the important right for minority institutions to set up, to actually set up and admit students of their choice in Article 30. Now, each of these rights is something which the courts are told, and this is again very important to remember. Fundamental rights are basically addressed to the courts. So it is an independent judiciary separately set up under the Constitution, which deliberates on these rights, enters into a balancing act in each case that is before it, between the citizen and the state, and then decides either in favor of the citizen or in favor of the state. When we come to directive principles of state policy, as I told you, these principles really emanate from a constitution which is Roman Catholic. And our two basic directive principles we find in Article 39b, small b and small c. And they run as follows. They say that the ownership and control of the material resources of the community shall be so distributed as best to subserve the common good. That's B. And C is that the economic system does not result in concentration of wealth to the common detriment. Now, both these things are directly lifted from an encyclical, that is a letter written to the bishops by Pope Leo XIII as far back as in 1891. So we have these Catholic concepts directly lifted and put into our constitution. And these Catholic concepts, therefore, have given birth to a large number of legislations which are beneficial socially and which is supposed to now usher in the social revolution that our constitution thought about. Other than these directive principles, of course, you have free legal aid as a matter now of right. You have workers now being looked after in various ways, equal pay for equal work, good living wage, etc. You have a concentration on the weaker sections to see that they are uplifted. You also have an article which speaks of prohibition of intoxicating drugs and intoxicating drinks so far as they are detrimental to health. Of course, you also have, in another part of the Constitution, the fact that you may impose an excise duty on these drinks, so that if you are not so minded to prohibit them, at least you can earn some money on them. So all this we find in the directive principles of state policy. And B.N. Rao, Sir Benegal Narsingh Rao, was really the gentleman who first drafted our first draft of our constitution. Somehow had a very peculiar notion that directive principles of state policy were all important and fundamental rights have to subserve them. Fortunately for us, the Constitution founding fathers emphatically rejected this and made it clear in Article 37, which is again of fundamental importance, which appears in the Directive Principles chapter, that though these directive principles, like rights, are fundamental, they are fundamental in the governance of the country and they will apply to the legislature and the executive. But most importantly, they will not be justiciable in courts. So the scheme of the Constitution was that the directive principles of state policy will guide the way for legislatures and the executive, and the courts will then test such legislation on the ground that they either violate or they do not violate fundamental rights. Now, this was all very well until very early in our constitutional history in 1951 itself. Without waiting for the parliamentary election which was to take place in the next year, the same provisional parliament which was the Constituent Assembly rushed through our Constitution First Amendment. And the reason for that rushing through was that the government of the day was very keen that agrarian reform measures go through and do not get stalled. Now, even though there were 3 such measures tested in courts, 2 of which were upheld by the courts, only the Patna High Court struck one down. They were in such a hurry they didn't wait for the Supreme Court. And they rushed through the First Amendment, which included 2 articles which upset the scheme which I have just given you. The scheme is what? The scheme is fundamental rights are fundamental in their sphere, in the sense that citizen against state, the citizen can then enforce them. And directive principles are fundamental only in governance, so far as the legislature and the executive is concerned. The waters now get muddied. You now have an Article 31A and an Article 31B, capital, for the first time by this First Amendment way back in 1951. Now, what do these articles do? They subvert this scheme. They say that the moment there is an agrarian reform measure under 31A, then out go all fundamental rights. All fundamental rights, fortunately, by the Constitution, 4th Amendment, was changed to Articles 14, 19, which, if you remember, I spoke about, equality and those 7 rights, and 31, which has now gone, which is a property right. So, at least from the 4th Amendment onwards, the moment there is a contest between an agrarian reform legislation and equality rights, all the rights contained in 19, 14 and 19 go out of the window. Fair enough. But then comes the next article, which article was really meant to be an adjunct to 31 capital A. That article is almost in the nature of a black hole in the universe of our Constitution. It is an extremely drastic provision. It is open-ended and basically says, without prejudice to Article 31A, the moment any act passed by either Parliament or the state legislature is put into the black hole, which is the 9th schedule, then what happens? Out go all fundamental rights, number 1. Number 2, and most important, it is not subject specific. Now, early on, the courts could have read it to mean subject specific, but unfortunately, in a 1965 judgment in N.B. Jijiboy's case, Chief Justice Subarao said 31B is independent of 31A. Had they said no, they were all part of the same scheme. It was like a validating act provision. And therefore would have been tied only to agrarian reform, a lot of the problems you would have had later would have gone. But no, that was not the way out. So therefore, 31B stood as a massive roadblock qua every single fundamental right. The moment any legislation on any subject is put into this black hole. Worse than this, it goes on to say that even if there has been a declaration of a court, which declaration says that that particular statute violates, let us say, Article 14, the statute springs alive by virtue only of it having been put into this black hole. Now, 31B, unfortunately, was not really tested in any real sense, because in the very first judgment in 1952, Shankari Prasad Singh, the Supreme Court said that, look, it's after all a constitutional amendment, so how can we touch it substantively? Golaknath, which was in 1967 judgment again of 11 learned judges, by a razor-thin majority, said, thus far no further, and therefore upheld it. Now, thus far no further means 31B continues, not that it goes. And finally, in Keshavananda Bharti, as all of you know, in 1973, they put up the basic structure test, and they said any constitutional amendment that violates basic structure must go. So 31B was never really tested on the ground that it is a terrible inroad into separation of powers, and it's a terrible inroad into fundamental rights generally. So that finally in the judgment in Vaman Rao in 1981, a 5-judge bench held, all right, we will restrict 31B from now onwards. Every act put into the 9th schedule will have to be tested on the ground of basic structure. All right, so far so good. Now the next conundrum was, are fundamental rights part of basic structure? Wasn't answered directly. In fact, Justice Khanna's judgment, the pivotal judgment in Keshavananda Bharti, had said the right to property is not part of the basic structure. And by the time it came to be tested in Vaman Rao, the right to property had gone in 1978 altogether. Vaman Rao spoke of basic structure, and finally Vaman Rao itself came to be referred to a larger bench in I.R. Coelho. Now Coelho was a 9-judge bench, and Coelho could have done could have done many things so far as 31B is concerned. It could have said fundamental rights are part of basic structure, which it did. But then it went on to say that, however, some fundamental rights may not be part of basic structure. Now, I fail to realize which fundamental rights would not be part of basic structure in 2005 when property has gone. Perhaps the title provision, Article 18, but short of that, everything is fundamental. And they are all rights, as I told you, which naturally inhere in us. But anyway, they went on to have now a 2-tier test, which again muddied the waters. The 2-tier test now was that first you would have what they call the rights test, and thereafter the essence of rights test. What does that mean? That means, does the law contravene a fundamental right? If the answer is yes, then does it contravene the very essence of that right or not? Now, to a small man, if there is some arbitrary pension scheme which takes away a large part of his pension, it is as egregious an infraction of Article 14 as an infraction of Article 14 can be to anybody. So it's very difficult to understand this core and penumbra kind of test which they laid down, and which therefore kept 31B alive so far as core and penumbra were concerned. But anyway, this is the law that we now have, and this is 31B as it now stands. We now come to 31C. Now 31C is a sort of bringing back to fruition B.N. Rao's emphasis that fundamental rights run subsidiary and are subservient to directive principles. But long before 31C comes into force in 1971, we had a communal GO challenged in 1951 Why was it called a communal geo? Very peculiar geo where in engineering colleges, medical colleges, etc., you had 14 seats reserved. 6 were for Hindus who are non-Brahmin. Then you had 2 for Brahmins, you had 2 for Harijans, you had 2 for OBCs, you had 1 for Muslims, and you had 1 for Christians. And this communal geo came to be challenged in the Madras High Court and then here. Justice Das, as he then was, struck down the communal geo and in striking it down said, fundamental rights are most important and directive principles are in fact subservient to them. Why did he say this? He said this because, according to him, if you read Article 13 and you read Article 37, it becomes clear that fundamental rights are to be enforced. Under 37, they are not enforceable in courts, so they must run subservient. The same thing was echoed in Muhammad Hanif Qureshi's case, which was a cow slaughter case. Now, incidentally, that cow slaughter case was upset in 2005 by a bench of 7, where they said that the balanced view that Qureshi took is no longer balanced, because even though cattle may not be useful for giving milk or as draft cattle, nonetheless, if there is legislation which says you cannot touch them, you cannot touch them. It's not a coincidence that 6 of the 7 judges were vegetarian, and the minority judge was the sole non-vegetarian. But anyway, to come back to 31C. 31C now for the first time gives a limited sort of scope to the B.N. Rao vision, which is that you have any law now made in pursuance of Article 39B and C, which if you remember I told you, were those 2 great Christian Catholic precepts of ownership and control of the material resources, etc. So any law made in pursuance of these 2 cannot be touched under Articles 14 and 19, which are the equality principle and those 7 other principles. So 31C then became the subject matter of challenge in our most numerously populated bench of Kesavananda Bharati, which consisted of the maximum judges who ever sat, 13. And 31C was upheld by 6 judges on the ground that in any case, according to us, a constitutional amendment cannot be struck down. So there was no basic structure test applied to it. It's only the 7th judge, Justice Khanna, who applied basic structure and who struck down what is called the last part of 31C, which precluded even a limited judicial review of going into whether the law was in fact in pursuance of Article 39B and or C or not. Anyway, as things stood, for the first time, there was a full-blown challenge to 31C in the same Vaman Rao judgment in 1981. And Vaman Rao somehow or the other said, we are bound by 13 judges, end of matter. Not correct, because basic structure had never been applied to 31C. If you remember, the majority 6 had said 31C has to stand whatever it is, because we can't touch constitutional amendments. It also went on to say, we find it very difficult to conceive of a case which would violate 14 or 19 if a law were truly under Directive Principle 39B or C. Now, this is really specious reasoning. You remember 19(1)A is the single most important thing or single most important right in a democracy, the right to free speech and the right to freedom of press. Suppose there were a law which said that all newspapers over a certain circulation of X were now either to be nationalized, now state-run, or to be shut down altogether, because what we want to do now is we want to distribute material resources of the community for the common benefit. And the result would be that all the daily newspapers which are critical of government would therefore be shut down. Such a law would pass muster straight away. So when both Justice Khanna and Vaman Rao spoke of no law being made in pursuance of 39 BFC, violating 14 or 19. They completely forgot the most basic cardinal right in a democracy, freedom of speech. Because don't forget, 19 is not just business rights, not just property rights which have gone. The most fundamental right is the right to freedom of speech and press. So, most unfortunately for us, 31C continues on the statute book as originally enacted. In 1976, B.N. Rao's vision was fully now realized, because instead of merely 39B and C, 31C now read all directive principles. So now you had every single directive principle and any law made in pursuance of any directive principle. The moment the law is made in pursuance of a directive principle, out go your two most basic rights, equality and all the 7 rights contained in 19. This came to be tested in what is called the celebrated Minerva Mills judgment. And fortunately for us, this enlargement of the scope of Article 31C did not stand scrutiny, and the court struck it down. The court correctly, for the first time, spoke of fundamental rights and directive principles being two wheels of a chariot, spoke of the balance to be maintained between them, and that the balance would be maintained between them by a means and ends analysis. Directive principles are ends to be obtained by the state. The means through which they can be obtained can only be through fundamental rights. And once this is viewed correctly, as it was in Minerva Mills, everything becomes crystal clear. And they went on to say that directive principles of state policy are contained in every constitution, totalitarian or otherwise. Fundamental rights may also be in totalitarian constitutions, but without any enforcement machinery. The difference between our nation and those nations is the rights that are there and the enforcement machinery. And therefore, fortunately for us, the enlarged 31C, which is B.N. Rao's vision, which was rejected by the Constituent Assembly, was also rejected by our court, most fortunately. So that today we actually have 31B controlled somewhat by this basic structure doctrine, and 31C back to where it originally came from, which is 39B and C, and not all directive principles. I hasten to add, there is a 9-judge bench matter, Property Owners Association, which is still pending before the Supreme Court. And one question raised in that bench is as to whether 31C continues to exist at all. And the point raised is that the moment you substitute all the directive principles for 39B and C, and you strike down all directive principles, then there's a void in 31C, because the original 39B and C doesn't come back. Now, if there's a void, 31C falls. But even assuming that argument won't work, I only wish the court were to go into 31C all over again, with particular regard to the fact that 19(1)(a) is a matter which is of fundamental importance to any democracy. And if a 19(1)(a) right can be snuffed out by taking heed to 39B and C, we will be no different from China or Russia. Coming now to the fundamental duties chapter. The fundamental duties chapter was introduced in 1976 by the Swaran Singh Committee. The Swaran Singh Committee had some 8 duties, 2 of which were that every citizen must pay his taxes, number 1, and number 2, every citizen must follow the directive principles of state policy, which unfortunately for us are not in fundamental duties today. You'll remember Benjamin Franklin had said that there is no certainty except death and taxes. But what Benjamin Franklin could not conceive was taxes that cause death. And the taxes that caused death in 1976 were the income tax, which was at a peak of 97%, with a wealth tax which, if you were eligible to pay that, would come to 103%. So, fortunately or unfortunately, the Swaran Singh committee was not followed, perhaps for this very basic reason. And this fundamental duty to pay taxes is not part of that chapter. The Swaran Singh committee also had one other interesting provision, that Parliament is to pass a law penalizing persons who do not, or citizens who do not, obey their fundamental duties. That again was dropped. So that today we have 10 fundamental duties with an 11th added much later. And those 10 fundamental duties are in the nature first of moral precepts and also in the nature of civic duties to one another. Now you will remember, the fundamental rights chapter is citizen versus state. The directive principles of state policy chapter is state, that is legislature, executive, being made to follow directive principles while making laws. The fundamental duty chapter is moral precepts plus how a citizen now is to behave with other citizens. Now the first fundamental duty that you find in Article 51 capital A is that you are to abide by the Constitution, its ideals, its institutions, and respect the national flag and the national anthem. Now, I ask myself this question. How would you abide by the Constitution unless you know what the Constitution is to start with? So isn't there some duty cast on the government of the day to spread constitutions all around in every single possible language so that the citizen is first made aware of what his constitution is, what his rights are? So it is important that these moral precepts actually come down to everybody. And the manner of their coming down, it's a suggestion by me, should be that the government of the day should distribute free of cost copies of the Constitution of India in every possible language, so that every citizen knows what this basic document is and what his rights are. Apart from this, you are then told that you must, for example, uphold the sovereignty and unity of the nation. You must have before you the struggle that all our freedom fighters had and appreciate what they did. Again, how do you appreciate what they did unless you know what they did? So same thing that goes for the first goes for this. Then, of course, you have as the fourth fundamental duty, if you are called upon to defend the nation, fine. But the fifth fundamental duty is of crucial importance. And that fundamental duty is the cardinal value of fraternity, which is now for the first time put in our fundamental duty chapter. You didn't find it in fundamental rights. You didn't find it in directive principles. And here you are told that it is of extreme importance that every citizen honor the other citizen, and in a spirit of brotherhood, transcending, most important, the key word is transcending, religious, sectarian, and other vociferous tendencies. And apart from this, to abjure practices which are derogatory to women. Now, if you remember, Sir Charles Napier was one of the old English generals. He was the famous general who sent a message back home saying, "Peccavi, I have sinned," if you remember. Now, peccavi is a Latin expression which means I have sinned, S-I-N-N-E-D. When he conquered the province of Sindh, he said this. So the same gentleman asked some procession as it was going along, "What are you doing to this poor woman? Why have you trussed her up like this?" So these people answered him by saying that, "Look, there is our custom that when the husband dies, the wife accompanies that husband to his heavenly abode, and that can only be by us forcibly throwing her into his funeral pyre." So he said, "Oh, is that so?" So very good, you carry on your custom. We otherwise have another custom. Our custom is that persons who abet or murder innocent women will be hanged. So you carry out your custom, I will carry out my custom. Now, apart from these other great precepts, we have a great fundamental duty in abjuring violence. We have a great fundamental duty in looking to and respecting our composite culture. Extremely important. According to me, fraternity is something which is very, very important so far as this nation is concerned, particularly at this time. And we know that the criminal law is sometimes put in motion selectively. But I am going to suggest a remedy. And the remedy is this, that civil courts should take up a suit filed by any citizen against, say, hate speech. What is hate speech? After all, it disrupts harmony. It disrupts brotherhood, right? So, the moment a citizen petitions a court against hate speech, the court can not only issue a declaration and an injunction because of the fundamental duty, it can also award punitive damages. Nothing hurts more than that which hurts the purse. So, if courts were actually now to take cognizance of civil suits in which these three things are done, it would go a long way towards preserving and protecting fraternity. I must say, fortunately for us, a recent Supreme Court order went out of its way to say every authority must act the moment there is hate speech. And if the authorities don't act, there will be contempt of court. One good step in the right direction. But I feel that a very, very important step is a civil step which you can now take, given this fundamental duty. And given also the fact that the fundamental duties chapter, unlike both fundamental rights and directive principles, is silent on what the court's role is. You can fill it in, and a civil suit can encompass any civil right. And this is not just a civil right, it's a constitutional right. It's something higher than any statute, it's right up. So, if we are actually going to live by the cardinal principle of fraternity, which I repeat is the only constitutional method, only, there's no other method, only constitutional method of assuring the dignity of every individual citizen of this country and of assuring the unity and integrity of the nation, then it must be given some teeth. And I can only quote from Justice Jackson's great judgment in West Virginia Board of Education versus Barnett, which was that Jehovah's Witness case of 1943, where they refused to salute the US flag. And Justice Jackson upheld their right not to salute the flag because they had a serious, conscientious religious objection to it. And so far as our great country is concerned, these words apply all the more because of the massive diversity that this country has, unlike America. And the words are, if there is any fixed star in our constitutional constellation, it is that no official, high or petty, will be allowed to prescribe what is orthodox in politics, nationalism, religion, or any other mode of thought. Beautiful words. It is only when no official is allowed to interfere that diversity becomes unity, not otherwise. And I only end this talk now with another Jehovah's Witness case, this time from our Supreme Court. Justice Chinnappa Reddy's great words, where he ends Bijo Emmanuel, which was another case where the Jehovah's Witness children refused to, they stood up, but they refused to sing the national anthem, again on a religious ground. And he put it beautifully when he said, our tradition teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it. Thank you very much.
Thank you, Justice Nariman. He deserved a standing ovation for such a speech. Let me also, on his speech, I have a couplet, and on fundamental rights and duties, I must tell you this. सींचा है इसे खून से हम तिश्ना लबों ने, सींचा है इसे खून से हम तिश्ना लबों ने, तब जाकर इस अंदाज का मैं खाना बना है. I will now request our President, Justice Lokur, to give his presidential address.
Thank you, Ijaz. Justice Rohinton Nariman, Mr. Raju Ramchandran, and all the distinguished guests over here. It's a very hard act to follow after Rohinton's brilliant exposition on fundamental rights, directive principles, and on the fundamental duties. So let me not take away anything from that. I just wish to say a few words about Mr. Tarkunde or Justice Tarkunde. This is in addition to what Raju has already mentioned about him. He was a judge of the Bombay High Court from 1957 to 1969 when he resigned. Now, at that time, Mr. Nariman, a highly respected member of the bar, described his judgeship in the following words. He administered justice, not just law. Now, these are extremely important words, particularly in the context of what Rohinton has told us about the fundamental rights. Later, Mr. Soli Sorabji, another distinguished jurist whom all of you know, described him in a full court reference in the Supreme Court as undoubtedly the most distinguished judge of the post-Chagla 1957 period. So it is not as if his greatness came after his tenure as a judge. He was great right from 1957 onwards. After his resignation from the Bombay High Court, Justice Tarkunde, who is better known as Bhau, set up practice in the Supreme Court, where he practiced in constitutional cases and public interest litigation. But his forte was civil liberties or fundamental rights, and he was the founding president of PUCL. In fact, his work came to be described as the founder of civil liberties movement in India. Mr. Tarkunde was a prolific writer, and his contributions as editor of the Radical Humanist, a monthly journal funded by him, is testimony to that. In the Radical Humanist of 1st April 1993, he published his J.P. Jayaprakash Narayan Memorial Lecture, delivered on 23rd of March 1993. 30 years ago, he stated presciently, and I would like to quote this: "The danger of Indian democracy being replaced by a personal dictatorship did not altogether disappear with the lifting of the emergency on 23rd March 1977. The danger of authoritarianism reappeared with the success of Mrs. Gandhi in the post-emergency election of 1979-80, and it continued even under the unprincipled regime of Rajiv Gandhi. After Rajiv Gandhi's tragic death, however, the Gandhi-Nehru family has ceased to be in possession of political power, and the danger of personal dictatorship has receded into the background. In the meantime, however, a graver and more serious danger to Indian democracy has reappeared on the horizon." Now, I'm not sure if I should read the rest of what Justice Tarkunde said in his lecture, but the written paragraph concludes, "If this happens, the secular democracy in India is liable to be replaced by a potentially fascist theocratic state." He said this 30 years ago, and I would request all of you, if you can get this through Humanist Eyes by Mr. Tarkunde, that contains the entire lecture, including the passage which I do not wish to read. Now, in the context of today's memorial lecture on rights, duties, directive principles, what is fundamental, it assumes great significance. It is a topic that is at the core of our Constitution and is truly fundamental to democracy. And I'm glad that we have a distinguished jurist like Rohinton to tell us all about it and to guide us and also suggest what can be done by the Supreme Court in the near future. I would also like to add that since he was talking about the courts, again, Mr. Tarkunde had said way back, this was in 1984, even before 1993, he said, "It must moreover be borne in mind that graft and nepotism are not the only factors which affect judicial integrity. Judges are liable to be subject to other indirect pressures. One of these indirect pressures is the judge's perception that the government, and in particular the central government, is extremely keen for upholding the executive or legislative measure which is being challenged before it. It is known that several judges of even the Supreme Court are indirectly and subconsciously affected by such a consideration. After all, judicial integrity is only one facet of judicial independence." Now, these are really prophetic words of Mr. Tarkunde, 1984, 1993, and he goes on talking about judicial independence and something which has been adverted to in a sort of an indirect way by Rohinton on how the Supreme Court has interpreted the Constitution and various provisions of the Constitution. So really, I think today's lecture was a fitting lecture, considering again, as Rohinton said, in today's times, fraternity undoubtedly is extremely important, but so also is judicial independence and judicial integrity. So with these thoughts, I would leave you and thank you all for being here to participate in this wonderful lecture. Thank you.
We are almost coming to the end of this program, but for Mr. Tarkunde, I have one couplet. And for this program, which all these lectures which have been delivered today, न साथ देंगी ये दम तोड़ती हुई शम्में, न साथ देंगी ये दम तोड़ती हुई शम्में, नए चराग जलाओ कि रोशनी कम है. I will request Mrs. Manik Karanjawala to come and give a memento to our chief guest, Justice Rohinton Nariman, and also a shawl on behalf of the Tarkunde Memorial Foundation. I will also request all members of the Tarkunde Memorial Foundation to come up on the stage. I will now request Mrs. Manik Karanjawala, daughter of Mr. Tarkunde, to propose a vote of thanks.
Justice Nariman, Justice Lokur, Mr. Ramachandran, Honorable Judges of the Supreme Court and the High Court, past and present, friends. When Rohinton speaks, the audience is always riveted, and today was no different. Thank you, Rohinton, for a scintillating address on a subject of very great importance. I have another reason for being particularly happy that Rohinton is our speaker today, because my late father was extremely fond of him.
Likewise.
Yes, and regarded him very highly, not merely for his obvious brilliance, but for his qualities of honesty, integrity, and forthrightness, which he himself prized and stood for. So thank you, Rohinton, from the bottom of my heart. My tribute of remembrance to our former President and Vice President, Mr. Soli Sorabji and Mr. Ashok Desai, who left us a year ago, and Mr. Kuldeep Nair, who left us about 4 years back. They were our mentors and role models in every sense of the word, and we miss their invaluable guidance. I thank Live Law and Bar and Bench for streaming this lecture live for those who could not be with us today. And lastly, I would like to thank this distinguished audience, many of whom have extremely busy schedules, for spending their time with us today. I'm deeply grateful to all of you. Thank you very much.
ഗീജുവേ ഒരെണ്ണം ഗീച്ചിട്ട് പോണോ കേട്ടോ, ഒന്ന് ഗീച്ചിട്ട് പോണോ? ഓ ഗീച്ചിട്ട് പോണം. मेरा पास उतना सिस्टम है, देखा है लाइव लोग का भी बारह नेटवर्क हमारा नेक्स्ट वीक ये लोग का भी देखते हैं नेटवर्क का काम मैं अभी काट देता
कोई नहीं है खत्म हो എവിടുന്നാ
ഞാൻ ഇവിടുത്തെ ഞാൻ ലൈബ്രറിയും ഇതെല്ലാം ചെയ്ത് ഞാൻ തന്നെ വർഷങ്ങളായിട്ട് നമ്മൾ തന്നെ ചെയ്യുന്നത്. അല്ല ലൈബ്രറിയുടെ സാറാണ് മലയാളി ഉണ്ട് സാറ് മലയാളി ഞങ്ങൾ സുനന്ദ ഭണ്ഡാരയുടെ ഇപ്പൊ കഴിഞ്ഞ വീട്ടിൽ ഞങ്ങൾ തന്നെ ഇവിടെ ഭയങ്കര പ്രശ്നം നെറ്റ്വർക്ക് ഭയങ്കര പ്രശ്നം എന്നിട്ട് നമ്മൾ ഓടിച്ചു വരുന്നത് ഞങ്ങളുടെ റൗട്ടർ വെച്ചിട്ട് ഇവിടെ ജാമ പറ്റുമല്ലോ. പക്ഷെ അവരുടെ ജാമ വെച്ചു എന്നിട്ട് ഒരു വിധത്തിൽ നമ്മൾ ഓടിച്ചു നമ്മുടെ നെറ്റ്വർക്ക് വെച്ചിട്ട് ഓടിച്ചു. ഇത് ഫേസ്ബുക്കിൽ ചെയ്തു, യൂട്യൂബ് എന്റെ കയ്യിലുള്ള ഇതുണ്ട് സെർവർ കഴിഞ്ഞ ആഴ്ച ചെയ്തു. കഴിഞ്ഞ സുനന്ദ ഭണ്ഡാരയുടെ കഴിഞ്ഞ സ്പീച്ച് സുനന്ദ ഭണ്ഡാരയുടെ വേറെ വക്കീലല്ലായിരുന്നു. പക്ഷെ അത് തോന്നില്ല ഇത്ര ആൾക്കാരെ വന്നു. ഇന്നത്തെ ഇതൊന്നും ഞങ്ങളിപ്പോ നരിമാന്റെ കുറെ പരിപാടിയാണ്. പെർഫെക്റ്റ് സ്പീച്ച് പെർഫെക്റ്റ് स्पीच वो स्पीच पहले भी 2 साल पहले भी लिखी है, 1 साल पहले भी की उसका स्पीच देखने के लिए बहुत आता है. लेकिन लास्ट वीक में सुनंदा भंडारी ने इतना सुनाम भी नहीं दिया. लास्ट वीक फ्राइडे में ഞങ്ങളുടെ വയർലെസ് സിസ്റ്റം ക്യാമറ എല്ലാം ഫുൾ സിസ്റ്റം ഇന്ന് 2 കമ്പനിയുടെ ലൈബ്രറിയും ചെയ്തു ബാറാൻമെന്റ് ചെയ്തു. പക്ഷെ എന്താ റിസ്ക് എന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ ഈ നെറ്റ്വർക്ക് ഉള്ള ഹാബിറ്റാറ്റ് സെന്ററിനകത്ത് മുഷ്കിലായി ഇവരെ अपना नेटवर्क हो जाए. നമുക്കൊരു കുറഞ്ഞ വർഷം നല്ല ക്വാളിറ്റി 20 Mbps ആണ്. ഇത് ക്യാമറ क्वालिटी में फर्क कुछ इसमें फर्क नहीं है. इसमें बोले तो डिफरेंस आएगा नेटवर्क कम है. नेटवर्क कम है तो क्वालिटी कम है. ഇനി ഇത് വീട്ടിൽ കൊണ്ടിട്ട് എൻഡ് ചെയ്യുന്നു. അപ്പോൾ നമ്മൾ വൈഫൈ വെച്ചിട്ട്
ശരി എന്നാ
ശരി സാറാണ്
ഞാൻ ദ്വാരക്കല്ല
ദ്വാരക പറഞ്ഞാൽ
കാർഡ് നമ്പർ
സാറ് അഡ്വക്കേറ്റ് അഡ്വക്കേറ്റ്
അല്ല ഇല്ല ഇവരെ കൂടെ ഉള്ളതാണ്.
അത് ശരി
ശരി എന്നാ ഓക്കെ
ഓക്കെ താങ്ക് മോനെ അവനെ ഒന്ന് വിളിക്കണമല്ലോ നെറ്റുകാരൻ കോപ്പൻ